Hey, this is Vince Davis, and we're live here on Facebook, The Secret, How to Fight Child Protective Services and Win. And these are my office hours where I answer questions that you post or that you email me. Tonight I'm going to be answering a couple questions. The first one is from Karen. Karen from Illinois. Karen writes, I am the great grandmother of the children in question. I have been 2.5 years, child is now 3, and still in foster care. Court is aiming towards adoption to the foster parent. My grandson is the father. He had disabilities all of his life, has a legal guardian to handle his affairs. No guardian, but has mental health, learning disabilities. During the pregnancy, they both lived in my home. When the baby was released from the hospital, he came home. I mothered all 3 of them until the child was removed. I wanted to file for legal guardianship, but for the baby because ultimately there would be a need to be someone overseeing the child. The maternal grandmother bought me about it or talked to me about it and was ready to override her and go to the court when everything went wrong. The mother went to the hospital for an evaluation, and it goes on and on. I didn't realize that. I hadn't opened it up. So here's the question. Now remember, you're in Illinois, I'm in California. I practice in California. Do I ever practice outside the state of California? Yes, but I have to get special permission on a case by case basis. Now, I'm going to answer the question as if you were here in California. If you're the grandmother and you're trying to get custody of the child, you need to move fast and you need to move early. A lot of grandparents come to me when it's too late. The child gets bonded to the foster parent. There's an emotional, physical, and psychological bond, and it's hard to get that child away from the foster parent as time goes on. And naturally, they've had this little baby, and they've become bonded to the child, and vice versa, and they're going to fight to try to keep the child. A lot of cases that I go to or I'm involved with are these relatives who come in and trying to get the child. So come in early, come in really early, like the first court hearing or the second court hearing. Now, if you're in California, what you would want to do is file a de facto motion. Oh, but Mr. Davis, some people tell me I can't file a de facto motion because I didn't care for the child during the court case. Wrong. You don't have to have cared for the child during the court case. It could have been before. And in your question, you told me that you used to care for this child, or you mothered all 3, the mother, the father, and the child. So you can file that de facto parent motion. Now, there's a couple of other things I want to tell you. You don't have to parent the child at all. Under a case called N. Ray Charles S., Google it and read it, N. Ray Charles S., you can have standing in the case. Additionally, under California law, a child is allowed to have more than one parent. This child, what's called presumed parent status, where you get the same rights as the mother and father. And then you can fight for that child if you were a parent, and they would almost be compelled to place the child with you. Okay, so that's the first thing. De facto motion, presumed parent motion. You'd also want to file a petition to disclose the court records because, it's a confidential case and only parties are allowed to have records. You might also want to file a petition for guardianship, legal guardianship. A lot of people disagree with me on that, but I stand my guns on that advice. And you might want to file a petition for temporary and permanent guardianship. Okay, I hope I hope that answers your question, Karen in Illinois. But here's the big piece of advice: you need to go talk to an attorney in Illinois. You need to get some advice, and maybe, if it's a free consultation, maybe you will go and get advice from a couple of attorneys on how to handle this. So that's what I'd like you to do. Okay? Now, I had another question that was text to me, And this was the scenario. Um, it was from another state. I forget which state it was from. And the mother was alleged to have abused or risk of abusing the children. And she wrote in the question that after 7 days and before there was any trial, the judge sent the child to the father and closed the case. Now, obviously, I can only answer this question under California law. And under California law, the judge can't do that until you have been what they call adjudged, a risk to the child or have committed some type of abuse. And you get 2 trials in California before they can ship the child to the father in another state. You have the adjudication or jurisdictional hearing, and you have the dispositional hearing. So under the jurisdictional hearing, the social worker has to prove by preponderance of evidence, more than 50%, that you abused the child or are a risk to abusing the child. And if the social worker doesn't prove that, the case is thrown out. Now, let's say that the judge finds part or all of the allegations against you to be true, then you move to the disposition hearing. And the social worker has to prove by clear and convincing evidence that you're a substantial danger and no less restrictive alternatives. If the child is in foster care, there's a lesser standard. I think it's substantial risk if the child is placed with a parent. But in your case, in your question, child was in foster care and was getting ready to be shipped to the father. So you'd be entitled to have those 2 hearings. Now in California, if they detained the child temporarily from you and then shipped the child to the father and closed the case, I would argue that your rights, your constitutional rights for notice and an opportunity to be heard at a trial have been violated. Now, I don't know what the law is in your state. If the law is, as you've stated in your question, that they just started the case and then 7 days later they sent the child to the father, that would be okay. But if they sent the child to the father and closed the case, well, that's a problem. And I think that's a problem no matter what the state law is. It sounds like there's a federal constitutional problem. So you should speak to an attorney in your state and explore the issues of constitutionality, explores the issues of notice and a right to be heard and the opportunity to be heard. That's a 2-part test: notice, opportunity to be heard. In your case and in your description of the case to me, you didn't have, well, you had the notice, but you didn't have the opportunity to be heard to prove that the allegations against you were false. And so I would talk to someone about that and trying to get some type of appeal, perhaps on a constitutional basis, or maybe I don't know, maybe they did it wrong in your case. I don't know all of the facts, and I don't know the law in your state, but you've got to talk to an attorney. Now, I did a trial today in Los Angeles County, or I finished the trial. COVID had given us a big interruption, and now even though the court building is closed, they're doing trials here in Los Angeles County via, WebEx or Zoom or, Blue Jeans. That's this online stuff. And I think this is going to work. I did another trial like that in Alameda County, and in Fresno County, the judge told me they weren't technically advanced as LA was, and they were doing the hearings by phone. So, in California right now we're spiking, in particular Los Angeles County. So I don't know when the physical court building is actually going to open up, and we get to go in and do stuff in the courtroom. Today we had a witness that appeared by phone. It's not phone, but that logged in and appeared like I'm appearing to you online. So it gets a little interesting. Luckily, during the pandemic, when everything was closed down, I took a course online about doing trials and court hearings under COVID rules, which is, online. And it's quite interesting to have everybody online and you appear before the judge. But let me tell you about the case today. The case was an adjudication and disposition hearing. Now, rather, if you hear anybody use the term adjudication in juvenile dependency, you know they're old school. It's jurisdictional and dispositional hearing these days. So we had a jurisdictional and dispositional hearing, and it was a continuation. It was the finishing of the case. So let me tell you what happened. My client's main concern was to get her two children back. She had a baby and I think maybe an 8-year-old or something. I forget how old the child was. But here's what happened. I asked the social worker today on cross-examination, was my client a danger to the child, to the baby? Because they were recommending unmonitored visits. She said no. Then I asked her, well, was she a danger to the older child? Social worker said no. I didn't ask too many questions after that because the law says that at the disposition, in order to keep the child away from the parent, they must prove by clear and convincing evidence, not preponderance, clear and convincing evidence, that the parent is a substantial danger, not a danger, but a substantial danger, and there are no less restrictive alternatives. So I prevailed. The mother got her two children back today, and the court, in making its ruling, also said, this is a much different case than it was, months ago when we started. The parents had, and my client had in counseling to address the issues that brought her to court originally. So in this particular case, the judge did find part, or if not all, of the petition to be true in the jurisdictional sense, but as my client indicated, all she wanted were her children back, and we had to fight to get that. The social workers, went down swinging. They didn't want to give the children back. At the end of the case, even after the judge made the ruling, the social worker's attorney asked for a stay. Like a stay, judge. You know what a stay means? A stay means, judge, I think you made the biggest mistake, and I don't want you to give the children back today until we have time to go to the Court of Appeals. The judge denied that stay. So my client got to go home today, or got to go home and go pick up her children, who were luckily in a friendly relative's care, still foster care, and get her children back. I'm going to be texting her later on this evening to make sure everything turned out all right. Well, I started late tonight. Had some technical difficulties with the HP laptop. So right now I'm on a MacBook Pro. But I want to wish everyone a good evening, and we'll see you tomorrow at morning office hours at 6:30 a.m. Pacific Standard Time. Now, you're probably watching this video. You have a CPS case, or you know someone that does. Or perhaps you're a relative that's trying to get the child in your care. I answer questions like these questions every day, all day. So if you have a question, give me a call. Be happy to answer them. Check out my resources at my website, fightchildprotectiveservices.com. Listen to my radio show on KABC 790 AM in Los Angeles, 7 p.m. Pacific time to 9 p.m. on Saturday evenings. And also check me out on YouTube. I have a lot of resource videos where you can go and you can look at videos. And, if you're not, help your attorney and say, hey, I saw this video. Most attorneys won't be appreciative. They don't like to take advice from clients or questions from clients that they've heard, like on a video or something, or read a book or saw it in the newspaper. But at least you can get some information and perhaps break it to your attorney, or ask them nicely, or you know, maybe that the video will help you in your case. And it's always good to have more knowledge. I mean, these cases are won based upon the knowledge that you have. And a lot of people I run into or talk to, they don't have a lot of information about these cases, the law, evidence, procedure, local rules, state rules. There's just so many rules and laws and cases that affect, appellate cases that affect, the outcome of these cases in juvenile court. And probably, you know, going to jail is treated in the law as, one of the most important rights. But people that I talk to and represent, going to jail is nothing compared to losing their child. And that's the possibility of things that can happen in this case. Uh, they could lose their custody of their child for a substantial period of time, and they can lose their child permanently. I see on the questions for tonight, or the comments for tonight, Shanta has a question, but I don't see the question. So if you have a question, post it there. I'll look at it this evening or in the morning, and I'll try to answer at the morning hours tomorrow, or at office hours in the evening. Tomorrow's Friday, and I do these office hours Monday through Friday, 6:30 a.m. and 8:30 p.m. All right, so everyone have a nice evening, and we'll see you tomorrow morning.